I want you to stop talking, or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
You're supposed to act as a trustee.
Sir, you need to stop. You're being in contempt of court. You need to stop, or I'll have the officer assist you in stopping.
Well, Your Honor, I would like to also bring to you, I object, Your Honor, I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you entering.
I appreciate you behaving yourself this way. Because just listen, because you're coming in hot like you did before, I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that.
Johnson, that is case number 2024 TR 22, State of Kansas versus Danny Johnson, County Attorney Jill Gillette for the state. Mr. Johnson appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you could get right in front of that microphone, thank you.
Can you hear me?
I can. Sir, yes. You're charged in count 1 with speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count 2, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If, in fact, it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So
probably not eligible for diversion based on his driving record.
Oh, okay. Well, do you want to talk to an attorney then and discuss whether or not you have a defense? Or?
No, Your Honor, I would like to request a declaratory judgment due to there is no agreement for my performance under any agreement or commission of this court.
Well, I don't need an agreement from you, sir. So if I were
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
All right, I will then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you
I
time.
object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you entering a plea on my behalf.
Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue of
Your Honor, I would like to ask, who bring these charges against me? I should have the right to question.
All right, we're not going to have this debate right now. I've told you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
Well, I would like to call the state to the. I would like to call the state to the stand, Your Honor. The
I'm doing that,
state bringing charges against me. Who is it? How did I injure the state?
All right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor, I object to the proceeding, for I do not know the nature and cause of the proceeding.
I'm entering a not guilty plea. Missy, when is
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
You're supposed to act as a trustee.
Sir, you need to stop. You're being in contempt of court. You need to stop, or I'll have the officer assist you in stopping. Missy?
Well, Your Honor, I would like to also bring to USC 12203.
Deputy Miles,
and also Article 3, the judge must operate in good faith and good behavior. So therefore, if you're making a threat towards me, then
Deputy,
that's
if he's going to keep being contentious, I'm going to
court.
have you take him into custody on contempt.
Then that would be illegal search and seizures, Your Honor.
Wouldn't you need to go back?
It will.
All right, Missy.
It's false imprisonment.
I want you to stop talking, or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again.
Deputy Miles, could you come in and assist the defendant?
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to come to court. Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right. So your first right is to have a hearing date, and that is September 27th, 9 a.m. The second
Your Honor, I also have a right to understand the nature of this. I have a right to understand the nature of the cause.
If you don't want to listen to me, you can go to jail. Do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of the.
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out.
The sovereign citizen ideology often leads defendants to believe they understand the law better than trained attorneys. But the real danger is a kind of strategic blindness. When someone rejects legal counsel in a criminal case, they remove the only person trained to challenge the evidence, negotiate possible alternatives, and prevent critical procedural mistakes. And in many cases, those small mistakes quietly determine the final outcome of the case. Balance scale.
I just want to understand the nature and cause.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., You're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue. Does he have a bond? Looks like you do, because you failed to appear February 27th at your first appearance. So bench warrant was issued. Bond was set at $1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up $1,000 cash back in July 12th?
I'm still trying to understand the nature and cause of this allegation, Your Honor.
I will continue your bond unless you get yourself hauled into jail on contempt before you leave. I will continue your bond with the condition that you reappear here in person at September 27th at 9 a.m. So you've got your court date, you've got your bond, and we've talked about your lawyer. Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in, or have you been in, the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. And I'm going to have those officers escort you to make sure you do so. So, Ms. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers. The choice is yours. Either leave.
Yeah, I'm trying to understand.
Or leave disruptively.
I'm not being disruptive. I'm just trying to understand the nature and cause of the charge.
All right, officers. I'm gonna close.
What am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief,
all I'm asking is to understand the charges. This is for the record. You said it's for the record, so I'm trying to understand what am I being charged?
The charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your oath to give that.
With you. If you tell me what kind of questions you have, I'll be happy to answer them. But I've already told you.
Okay. Under what jurisdiction is these charges being brought to me under?
The state of Kansas has charged you with speeding 82 and a 65 and operating in a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance, and a bench warrant was issued, and you were arrested, and you made a bond of $1,000 cash or surety, posting a cash bond. Now you have to go to court, and you have to answer those charges. You can
Your Honor,
have a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being charged under the jurisdiction of the state of Kansas under its criminal.
But according to the Constitution, there are only two jurisdictions.
All right, we'll have that on a later date. We'll be at recess, officers. Please escort him one way or the other, depending on his behavior.
But I'm still not understanding what you're charging me with.
Goodbye. We are adjourned.
But if she's the judge, I'm supposed to have clear and concise of what I'm being charged with.
You give us any problems with it?
I'm not giving y'all a problem. I'm trying to.
All right, put you in handcuffs.
Well, I'm waiting on this, Your Honor, to explain.
All right, Missy.
But that's it.
That's our last case on the docket, isn't it?
This is not good.
Yes.
All right. All right. Ms. Gillette, I'll see you at 3:30 docket.
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
All right. Well,
Can I go home?
I left it up to them, and I left it up to you, and then they were to behave accordingly.
Confused on behalf of the club.
Sir, state your name, please.
I'm George Stone.
All right. This date time set for preliminary examination. Mr. Styron, you are here representing yourself. I would indicate to you that there are 3 charges on the complaint in this case. The first charge is that of fleeing a police officer under the Motor Vehicle Code in the 3rd degree. That is a felony punishable by up to 5 years and a $1,000 fine plus court costs. Count 2 on the complaint alleges assaulting, resisting, and obstructing a police officer. That is a felony punishable or a high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a charge of driving while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a $500 fine plus court costs. The subject matter of this preliminary examination is for the people to establish by probable cause that the felonies have been committed. If the people do establish that, then you would be what's called bound over to stand trial in the circuit court. You are here appearing without counsel. I would advise you that if you wish to represent or be represented by counsel, you can let the court know, and the court would make sure that counsel would be available to you in this proceeding. I would also indicate that if you are desirous of continuing to represent yourself, you certainly have an absolute and constitutional right to do so. You will be held to the same standard that attorneys are held to regarding the court rules, regarding the presentation of evidence, and anything else along those lines, as well as questioning of the witnesses. Do you understand all of that, sir?
I understand everything.
Pardon?
I don't understand everything.
Okay. And, sir, do you still wish to proceed unrepresented? Very good. Do you have any questions before we begin the preliminary examination?
I haven't had a chance to look at the body cam and the evidence. I just got a kite back yesterday telling me I could ask the noon staff to be able to view this. I've got maybe 45 minutes or an hour's worth of time in it so far. I'm able to get through the first video.
45 minutes, an hour into what?
I think there's 16 videos on the thumb drive. And I think Officer Hooks is an hour and 15 minutes long in itself. So what I'm saying is I've had insufficient time and evidence to even review it, to be able to articulate it.
Excuse.
Your Honor, I understand that the APA that was present before me had intended to admit that some of the body camera. I will not be using any of it today. I'll be proceeding with just Sergeant Howe's testimony.
Right. I guess and I understand that misuse, and I guess the only question would be if whether or not something contained on the body cam might lead to evidence that the defendant either would want to present or lead to evidence that the defendant may wish to question the deputy on. And I'm going to have no way of knowing that.
I appreciate that, Your Honor, especially because my office previously put on the record, and I'll reiterate today, we do plan on adding additional charges, the count of felonious assault, which is assault with a dangerous weapon against the sergeant, and 2 counts of felony firearm, which are mandatory 2 years in prison. So, Your Honor, I don't have a problem if we need to adjourn this room to have more time with the video.
Okay. Right. And under those circumstances, and I forgot, I think you had mentioned that before, that with that. Okay. So, Mr. Styron, you're requesting an adjournment of the proceedings so you can get through that. Is that okay? How far? I guess that was unclear. You have access to the body cam.
Yes, I do. It's in my property.
Okay. But then you were talking about you got through some of it.
The first video, and I believe it's a YouTube, not YouTube, but a Facebook video of a bystander.
Say that again.
Facebook video that somebody took.
Okay.
And part of his body cam, maybe 20 minutes, half hour's worth.
When you're saying his, you're talking about
Officer Hooks, yes.
Okay.
I believe his body cam footage is an hour and 15 minutes in its totality. So I've barely been able to scratch the surface of that.
Okay, let me ask you. Go ahead. Were you going to say something else on that?
And more, that's just what I was able to see.
Okay, so let me ask you this: How are you arranging to view that video?
So originally I was kiting everybody I could. I was correctional services, the sergeant, that sergeant. Finally, while down in correctional services, I was able to speak with Sergeant Flint.
Okay.
And he was able to arrange this first meeting. And like I said, I got a kite back from him yesterday telling me just to bother the noon staff, and they'll arrange it during the noon shift. So
Gotcha.
Prior to yesterday, I was still asking. I guess I was just asking the wrong shift. I was asking later in the day. That's for certain. And I really was never able to get anything else arranged as far as being able to go and view it.
Okay, so you were trying to do it one way, that wasn't happening. You finally got to Flint, and he indicated to you that it's the noon staff you're supposed to bother to try to. Okay.
Flint's definitely provided direction in regards to how I can go about getting this.
All right. Okay. So we'll need to then adjourn that. Have you, well, I'm going to ask it one or two ways. How long do you think it'd take you to get through it? I mean, how long do you think it'd take you to get through it? I mean, is it your, and I won't hold you directly to it, but I mean, would you be able to do it in one day if you had access to it, or is it going to take you a few days, or just your best guesses? Because you know how long the clips are. I don't have any idea by design.
I only have knowledge of how long his particular video is, Officer Hoops. I don't, the other ones I haven't looked at, viewed, can't remember how big the file is, nothing like that. If I was out in the world, I could probably have this done within a week at my house. I have my own computer, and I planned on originally being able to do this. Also, it depends on the jail. They've been so short-staffed. We've been locked down a lot as well. So it depends on what their staffing numbers is during it. When I'm asking or trying to arrange this, there's so many variables. It'd be hard for me to give you a...
No, that's fair. That's fair.
And then also...
But you don't know total time how much there is.
Right.
You just know that one.
Since May, I've been fighting an illness that just recently the jails addressed. So there's so many things going on. I've been since May. I've been having stomach issues, bowel issues, and on Friday or Saturday I was urinating blood. Finally, I was able to get some the medical staff to do something with that as far as me urinating the cup and give me some type of antibiotics. But all they can tell me is I have an infection. They just don't know specifically what type of infection. So I'm also dealing with that, and it's like very lethargic and
okay, I got you.
Energy in that.
What do we
that as well?
What do we look like on the 6th? Well, we've got stuff. It's a day like today. I got stuff in the morning, but then, okay, so that we hopefully won't run into this again. You've gotten all of the discovery.
Pardon me?
You got all of the discovery. Like you got as far as you know, you got the police report. You have all of that. It's the video. All right. So what I will do is I will adjourn the preliminary examination in this matter. I would go to the 30th, but I think I'll go to August 6th, 2024 at 1. I'm going to set it at 1 p.m. We'll just push everything else out of the way, and that way we'll be here. So that'll give you 3 weeks to try to get through that. Now, if there are issues like what you're talking about, short staff, whatever, and you haven't been able to get through everything, talk to one of the deputies so that they can get in contact with my office, so that if we have to push it out another week, we can just get that done without you coming up here and telling me you're not ready.
Fair enough.
Okay.
And a question in regards to is there any reason why that would be preferred instead of me being able to address what I got going on internally and at a hospital or outside in the world? I guess me being put on bond so I can take care of my illness as well as look at this discovery and handle that. So it'll probably be done in a more timely manner. There's less variables involved.
Your Honor, I'm not available before then anyway, so I'm very happy to come back in 3 weeks once he's had the opportunity to review it in the jail. And yes, as Your Honor is well aware, if this gentleman's ailments were to the level that he needed to be hospitalized, the jail would hospitalize him. Additionally, the jail would notify their chain of command if there were any needs that exceed the jail's current ability to assist him. I've received no communication from the jail to that effect. It tells me it's not happening, meaning that the jail is the appropriate place for him. Also, Your Honor, I will, as the court knows, the defendant is in custody without bond for the defendant's demeanor in this courtroom. At the time that my office charged this case, we requested a $50,000 cash surety bond. This is a person who, while possessing a firearm, threatened to cook the sergeant, which is one of the reasons that I'm planning to remand the information I had against him. Additionally, Your Honor, this case originally came in as a domestic violence call, and Sergeant Haupt took the opportunity to try to protect the community by proceeding after this defendant in a manner to not only protect one individual woman, but to protect our community. And it resulted in this person possessing a firearm and not only threatening the sergeant, but threatening the sergeant's dog as well.
My rebuttal to that is, when I said cook, I made it very clear. Said meant legally in the courts, which he iterated on his body cam. So according to the body cam video, he was fully aware that I meant legally through the court process. And also, I believe in the police report, he was sitting there for a welfare check with a possible wrong domestic, which led me being pulled over. Me being a single person in my van, not two people, which would be involved in domestic, I imagine. And then once pulled over, pretty sure he knew I wasn't who he was looking for, just based on my parents' description, based on who was looking up in his talent or the name system or whatever it is they use in the police cruiser. Make sure to iterate that I plan to use the legal system to address any transgressions or trespasses I felt was made against me. Also, I was the one who stayed on top of these charges. I'm the one who called the court every day, stayed on top of this case, and I'm the one who arranged the court date with Ms. Fink. I was the one who called the courts week after week, and they didn't have my case in, and finally they did. I was very proactive in trying to get this addressed through the court system. Had no intention of running or trying to avoid it at all. And I think my actions were sued such.
In this matter, I'm not going to, at this point, change your bond, Mr. Stern, and I'll just put it to you this way. I don't know the facts of the case. By design, I don't. So I'm going to certainly, I hear the allegations. I hear your response to the allegations, and at some point I'll see the evidence. In terms of what I had previously heard in regard to this case, I would consider your actions on that date, at least as I understand them to be at this time, that you pose a significant risk to the public and to public safety by your conduct that day. Okay, I'm not sure about the comments. We'll deal with that. Further, as the prosecutor indicated, your demeanor in the courtroom prior to today leads the court to question whether or not releasing you, I could trust you to do what I ask you to do. This is the first time today, as we were talking to each other going through the things, that it's been a civil conversation with you to try to resolve the things. All I'm trying to do is get the case through. I don't know why the other days you made a determination to try to act a particular way to the court, because I'm just, like I said, I'm just here trying to get the case heard and get everything done. And so I have, based upon what I hear regarding the case, what I also have seen in terms of your demeanor in the courtroom, I have great reluctance in terms of doing that. What I will tell you is this, is that I certainly will address, so I'm going to deny your request to the extent it was a request to change your bond in this case at this time. Certainly, hopefully we'll be able to go forth on the 6th, and I certainly will relook at everything on the 6th, and you could raise the issue again. But I want you to understand that part of it is because of what the allegations here are. And I'm not saying you're guilty of them. I'm not saying any of that. But in terms of the allegations and what could be and is, from this court's perspective, a situation where you may pose a risk to the community, but also a lot of it is of your own doing in terms of what happened here. Okay. And so all of that I have to take into and can take into consideration. But like I said, in fairness to you on the 6th, because today was 180 degrees from before. And so I will now factor that in. And on the 6th, certainly I will take a look at anything you just raised again before the court. Okay. And I would agree, just real quick, and I'll let you. I would agree with what Ms. Hughes has said, and that is that if your medical were to an extent, our jail is excellent. I have to say the sheriff's office is extraordinary in making sure that people get the medical care that they need. But certainly you would have to apprise them of that, and I think maybe you have, and they will make sure that you're taken care of. I just don't have a doubt in my mind and have never had an issue with an inmate getting the care that they need. So, all right.
Two things. 4 times we've been adjourned because I asked to represent myself. I don't believe my demeanor played any roles in that. I thought it was because there was some misunderstanding as far as the courts and me trying to represent myself.
Oh, no.
And then in regards to the medical thing, I reported this in May. It took until I got a blood in July before anything was ever followed up on or done.
Okay. I suggest that you send another request regarding the medical issue. And Mr. Styron, I would also suggest to you, it never is an issue. I've had 2 others come through representing themselves. That is never an issue with me because you have a right to do that. Yeah, and I'm just going to let you know, that is not the reason. You need to go back and you need to look at what you were doing in this courtroom or this court for reasons I don't even, Mr. Styron, understand. So I'm not here to debate that with you. I'm just telling you that's where it was.
What I was saying was, maybe I was misunderstood. That when we went to proceed with the court proceedings, there was some misunderstanding in regards to the public defender's office representing me versus me representing myself. Since there was that misunderstanding, it was adjourned, I believe, 4 times over those matters. It wasn't because I was acted out or anything. I believe I came and went so fast. It wasn't even obvious.
No, there were a couple of adjournments because of that.
Okay.
But that was because you needed, there was assistance you needed in regard to what we were dealing with at a particular given moment. And so that's where the PD was standing in. But no, it was your behavior on the date that I revoked your bond. And then the other dates were trying to make sure of that. And I was, just to be honest with you, Mr. Tyron, I wanted to make sure that you truly wanted to represent yourself and that your rights were protected with having the PD here. And until I was clear on that, I wasn't going to let things proceed because, well, I'll just put it to you bluntly, you got a hot head sometimes. And I wanted to make sure you weren't making that decision just because and not fully understanding what this was, because these are serious charges and there are potentially more that are coming. That's my whole thing on that. Okay.
I appreciate it.
All right.
One last question, if we're about to be done. In order to get a hold of your office, I can use the channel of the jail, not the mail system, because I don't have envelopes to pass information or anything. The jail is my channel that I go through to contact you and inform you of certain things, be it whether it's documents or
I'm not, well,
or in regards to me needing more time.
I think you would have to send some type of communication, written communication to my office. I don't think there's a direct line, and I'm not even sure how that works because I usually don't have inmates contacting my chambers directly. Sometimes they will mail things, which seems to me to not be it. Do you? Oh, there he is. So he'll figure that out. He'll let you know how to get a communication up to my office.
Right.
Okay.
Yeah.
And not whether or not I can do anything about it, I don't know. So when that happens, so that you understand this, Darren, whatever you send to me that I'm going to review needs to also go to the other side. But what I will do to try to make things easier, if this is okay with the people, is that once it comes to me, I will make sure that whatever you're sending to me, they're going to get a copy.
That works. Thank you.
All right, because envelopes are $1 and I have no money in my account, so it'd be very burdensome to try and buy envelopes to send to everybody.
They're $1? Seriously?
Tough down there.
I got about $500 in there. That okay.
So
Why? No, I'm just saying, if I can sell them for $1, I'll just take the whole box down. Anyway, okay. So we sorted that out. Make sure to get with them. They'll make sure it gets up to us.
perfect. Thank you.
Okay,
Yeah.
Mr. Syra, I appreciate you behaving yourself this way, because just listen. Because you're coming in hot like you did before, I'm just going to let you know, with me or any other judge, that's a battle you're going to lose every time.
I can appreciate that, and my only response to that is I've never had that happen. I mean, all the other judges have ever had going for whether traffic or Miss Fink that was able to have a conversation after the court time.
She's nicer than I am.
She's a very nice woman, that's for sure. And
She's much nicer than I am.
like I said,
And so she has patience. Sometimes I don't.
fair enough.
So you got to take it as it is. All right. Thank
Thank
you. You do the same.
Thank you.
Courtrooms don't operate on personal belief systems. They run on procedure, jurisdiction, and credibility. In the first case, the defendant treats the courtroom like a debate stage. He uses sovereign citizen language, questions the court's jurisdiction, demands to know the nature and cause of the charges, and refuses to enter a plea. It may look like he's taking control of the situation, but legally those tactics accomplish very little. When a defendant refuses to plead, the court can simply enter a not guilty plea on their behalf, and the case continues without their cooperation. That's the real strategic trap. The defendant believes resisting the process protects his rights, but in reality it only removes his influence over how the process unfolds. The second case shows the opposite dynamic. Here, the judge isn't debating legal philosophy or authority. Instead, the focus is on risk assessment, public safety, courtroom behavior, and credibility. Bail decisions rarely depend on arguments about the law. They depend on whether the judge believes the defendant will follow orders and return to court. That's why courtroom demeanor matters far more than many defendants realize. Every interruption, every attempt to challenge the judge's authority, and every refusal to follow the structure of the hearing slowly shapes how the judge views the person standing before them. And once a judge begins to see someone as unpredictable or uncooperative, the consequences escalate quickly, affecting bond decisions, the judge's patience with procedural issues, and eventually even sentencing discretion. Across both hearings, the pattern is clear. The defendants believe the legal battle is about proving the court wrong. But the real battle is much simpler: whether the court believes they will respect the rules of the process. And once that trust begins to disappear, the courtroom becomes a much harder place to win. Balance scale.